There is a rule that many families do not learn until the worst possible moment. They learn it in a hospital room. They learn it after a fall. They learn it after a stroke. They learn it after a doctor says the words nobody wants to hear: long-term care. By then, the family is not thinking like a planner. It is thinking like a frightened family. The children are trying to find a facility. The spouse is trying to understand the bills. Someone is calling the insurance company. Someone is looking for bank statements. Someone is signing papers at the nursing home desk without really understanding the consequences. That is when the rule appears. Not as a warning, as a wall. The rule is called the Medicaid 5-year look-back. That name sounds administrative. It sounds like paperwork. It sounds like something a caseworker checks quietly in the background. But the name hides the real danger. It is not simply a look-back. It is a penalty system. It is a system that can punish a senior for ordinary family decisions made years earlier, often when that senior had no idea they were doing anything that could later cost them their home. That is why this rule is so dangerous. The danger is not only the law itself. The danger is that most families discover the law only after the 5-year planning window has already closed. That is the first principle. A financial rule becomes most dangerous when it is invisible until the moment you need help. If you are 65 or older, if you own a home, if you have savings, if you have children, grandchildren, a spouse, or anyone you hope to leave something to, you must understand this rule before the crisis arrives, not after, before, because once the crisis arrives, many of the best options may already be gone. Here is the basic structure. Long-term nursing home care is expensive. The source document describes an average cost above $108,000 per year. That is more than $9,000 per month for many seniors. Even seniors who saved responsibly, that kind of cost can drain a lifetime of savings very quickly. At first, the family may pay privately. Then the savings fall. Then the family applies for Medicaid. This is where many people become confused because they think Medicaid is simply the program that steps in when the money is gone. In a narrow sense, that is true. But before Medicaid pays, the state asks a very important question. What did you do with your money during the previous 60 months? The caseworker can review bank statements, property records, checks, transfers, gifts, and asset movements going back 5 years. Every transfer can become relevant. Every gift can become relevant. Every bargain sale can become relevant. Every dollar moved to a child or grandchild can become relevant. The state is not only asking whether you are poor today, it is asking whether you made yourself poor by transferring assets during the look-back period. That is the second principle. Medicaid does not only measure what you have now, it also examines what you gave away before you asked for help. And if the state decides that you transferred assets for less than fair value during the 5-year window, it can create a penalty period. The penalty is not a normal fine, it is worse than a fine. A fine is a bill. This penalty is a period of time during which Medicaid refuses to pay. The formula is simple but brutal. The state totals the value of disqualifying transfers during the look-back period. Then it divides that amount by a regional penalty divisor, which the source describes as often being around $10,000 to $12,000 per month. In many states, though the exact number depends on the state and region, the result is the number of months Medicaid will not cover the nursing home bill. During those months, someone still has to pay. The facility does not stop charging. The nursing home does not say, "We understand the government is imposing a penalty, so we will wait kindly." The bill continues, and that is where the trap closes. You gave the money away, therefore you do not have the money, but because you gave the money away, the state says it will not pay for a period of time. So who pays? That question is what destroys families. The third principle is this. The Medicaid penalty is dangerous because it creates a gap exactly when the family has no cash to fill it. That is the trap. Now, many seniors assume this rule only applies to large transfers. They imagine someone giving away a house, a brokerage account, or a large lump sum to avoid paying for care. They think ordinary gifts are safe. That assumption can be costly. The source document makes the point clearly. The look-back can catch many kinds of transfers. A Christmas check to a granddaughter, money for a child's wedding, help with college tuition, forgiving a family loan, selling a car to a nephew for $1. Certain charitable gifts, depending on the state and circumstances, small transfers can accumulate into a larger problem. There is no special birthday exemption. There is no holiday exemption. There is no "I did not know" exemption. The system is not built around your intent in the way families imagine. It is built around asset movement. This is why ordinary generosity can become dangerous late in life. A grandmother may think she is helping a grandchild. A father may think he is helping a daughter with a car repair. A widow may think she is giving normal holiday gifts. But if long-term care becomes necessary within 5 years, those transfers can be reviewed. That does not mean every gift automatically creates disaster in every situation. Rules and enforcement vary by state, amount, documentation, intent, and context, but the danger is real enough that no senior with meaningful assets should make transfers casually without understanding the Medicaid planning consequences. That is the fourth principle. A gift can be legal for tax purposes and still dangerous for Medicaid purposes. This distinction is critical. Many people know about the federal annual gift tax exclusion. The source document describes it as currently being $19,000 per recipient. Families hear that and assume that any gift under that limit is safe. But the IRS gift tax system and the Medicaid eligibility system are not the same system. The IRS may allow a gift for federal gift tax purposes. Medicaid may still treat that same gift as a transfer that triggers a penalty. These are separate rule books. The fact that one agency allows something does not mean another agency ignores it. This is one of the most common and dangerous misunderstandings in elder planning. A senior says, "I thought I could give that money away for tax purposes, maybe for Medicaid purposes." Maybe not. That is why general financial common sense is not enough here. You need the right kind of legal and Medicaid planning knowledge before the gift is made, not after. Now let us talk about marriage. Many married couples believe that if one spouse becomes ill, the other spouse will be protected. That belief is partly true and partly dangerous. There is a rule called the Community Spouse Resource Allowance. It is designed to prevent the healthy spouse living at home from being completely impoverished when the other spouse needs Medicaid, funded nursing home care. The source document says that in 2026, the maximum amount of countable assets, the ATTCT, is $157,920. At first, that number may sound reassuring. It is not as reassuring as it sounds because that money may have to support the healthy spouse for many years. Property taxes, insurance, Medicare premiums, food, transportation, home repairs, utilities, medical costs, emergencies, inflation, life. If the healthy spouse lives another 10, 15, or 20 years, $157,000 may not be a secure fortune. It may be a thin cushion stretched across the rest of a life. That is the fifth principle. A protection that sounds large in one moment can be small when measured against a lifetime. The nursing home may cost more than $9,000 a month for the spouse in care, while the healthy spouse is expected to survive on a limited protected amount. The emotional burden is terrible. The financial burden is often worse. This is why long-term care planning is really family balance sheet planning. It is not only about the person entering the facility, it is about the spouse left at home, it is about children, it is about heirs, it is about the house, it is about liquidity, it is about whether the family's entire financial structure was prepared before the crisis. Now let us talk about the house. This is the asset most seniors believe is safe. They believe Medicaid cannot touch the home. The truth is more complicated while you are alive. And depending on the state, your home may often be treated as exempt for Medicaid eligibility if you or a spouse are living there or if certain other conditions apply. Medicaid may not force you to sell the home before qualifying, but that does not mean the house is safe forever. After the Medicaid recipient dies, a different process can begin. It is called the Medicaid Estate Recovery Program. Federal law requires states to seek recovery from the estates of certain Medicaid beneficiaries, including those who were over 55 when benefits were paid. The state may file a claim against the estate to recover the cost of care, and the major asset in the estate is often the house. That is the sixth principle. The house may be exempt while you are alive, but exposed after death. This is the part many families never understand. They think the house is protected because Medicaid did not force a sale during life. Then the parent dies, and the children receive a letter. The state has a claim. The estate owes money. The heirs must either pay the claim or sell the home. The house that was supposed to become an inheritance becomes the repayment source. The source document states that the average estate recovery claim now exceeds $74,000, and in some states can be much higher. Whether the exact amount in any case is smaller or larger, the point is that estate recovery can be large enough to force a sale. This is how a family home disappears, not because a parent was careless, not because children were greedy, often because nobody explained the system early enough. The house did not vanish during the Medicaid application. It vanished during estate recovery. That is why families misunderstand the risk. The seventh principle is this: protection during life is not the same as protection after death. If you do not understand the difference, you may think you planned when you did not. Now, there is another layer that many people have never heard of: filial responsibility laws. The source document says that in 29 states, including Pennsylvania, North Carolina, New Jersey, Connecticut, and Georgia, older laws exist that can hold adult children financially responsible for certain unpaid care costs of parents. For decades, many of these laws were rarely used, but a Pennsylvania case in 2012 drew attention because a nursing home was allowed to collect $93,000 from an adult son for his mother's care. The point is not that every adult child will automatically be sued in every state. That would be too simple. The point is that unpaid nursing home bills can create legal exposure that families do not expect. Depending on state law and facts, the burden may not stop with the parent's estate. This is why the system must be understood before the family reaches crisis. That is the eighth principle. Long-term care debt can move through a family in ways people do not expect. The nursing home wants payment, the state wants recovery, the estate may be targeted. In some places, adult children can face claims under certain conditions. This is not a topic to treat casually. Now, the source gives an example of a widow in Ohio who transferred $45,000 to her daughter over 4 years. Birthday gifts, holiday checks, help with a car repair, nothing that felt unusual inside a family. She entered a nursing home in month 47. The state divided the $45,000 by Ohio's penalty divisor of $7,463 per month and imposed a 6-month Medicaid penalty. During those 6 months, the nursing home billed $9,200 per month. The total bill was $55,200. She did not have the money. The nursing home placed a lien against her house. Then she passed away months later. The state filed an estate recovery claim for additional care costs. Her daughter received a letter saying the home she grew up in was being sold by court order. That example is powerful because it shows the human reality. These were not exotic transfers. This was not a billionaire tax scheme. This was not hidden money in an offshore structure. It was family help, and in the wrong timing window, family help became the trigger for financial destruction. That is the ninth principle, the Medicaid 5-year lookback turns ordinary family generosity into a legal exposure if timing is wrong. Now, when families discover the problem too late, some attorneys may use a strategy known as half-a-loaf planning. The source explains it as giving away part of the remaining assets while using the other part to pay for care during the penalty period triggered by the gift. The idea is not that this is ideal, it is damage control. It may save something when there is no time left to save everything, but it requires precise timing, specialized legal planning, and must be done before the Medicaid application is filed. Once the application is filed, the strategy may no longer be available. This is important because many people think a lawyer can always fix things later. Not always. In Medicaid planning, timing can determine whether a strategy exists at all. That is the 10th principle. The later you plan, the fewer tools remain. Half a loaf is a late-stage tool. It is not the same as planning 5 years early. It is a salvage strategy, not a clean strategy. If you wait until the nursing home crisis, you may be forced into limited options that save part of the estate, but not all of it. If you plan years earlier, you may be able to protect much more. This is why the document named at the beginning matters. A Medicaid Asset Protection Trust. That is the phrase families need to know. A Medicaid Asset Protection Trust, often called a MAPT, is an irrevocable trust designed to protect assets from being counted for Medicaid eligibility and from estate recovery after the look-back period has passed. If properly drafted, funded, and administered under the applicable state rules, the trust is irrevocable. That word matters. It means you cannot simply take the assets back whenever you want. The trust owns the assets. You may be able to live in the house. You may be able to receive income from certain assets depending on how the trust is structured. But you give up direct ownership and control over the principal in order to start the protection clock. This is why it is not something to do casually. It is serious planning. You are trading control for protection. That is the 11th principle. Asset protection usually requires giving up something. If someone promises full protection with no loss of control, be careful. A properly designed Medicaid Asset Protection Trust may protect the home, savings, and investments after 5 years. The 5-year look-back cannot reach assets that were moved into the trust outside the look-back period. Estate recovery may not be able to reach assets that are no longer in the probate estate or that are structured properly under state law. But the clock does not start when you think about planning. It does not start when you watch a video. It does not start when you call an attorney. It starts when the trust is properly funded. That is the 12th principle. The 5-year clock starts when assets actually move. This may be the most important practical point in the entire discussion. A signed trust sitting empty does not protect assets that never moved into it. A good intention does not start the clock. A conversation does not start the clock. A note in a file does not start the clock. Funding the trust starts the clock if you set up the trust but fail to retitle the house, transfer the accounts, or move the intended assets properly. You may have paid for paperwork without real protection. This is why implementation matters as much as legal drafting. Planning is not complete when the document is signed. Planning is complete when the structure is funded and maintained properly. Now, the source also mentions Lady Bird deeds in 5 states: Florida, Texas, Michigan, West Virginia, and Vermont. A Lady Bird deed, also called an enhanced life estate deed, can allow a homeowner in certain states to keep the right to live in and control the property during life while transferring it automatically at death outside probate. It can accomplish part of the Medicaid planning goal for the home specifically, depending on state law. It is not the same as a Medicaid Asset Protection Trust. It is narrower. It may help protect the home from probate and potentially estate recovery in certain states, but the details depend heavily on state law. That is why you cannot take a generic internet answer and apply it blindly. Real estate law and Medicaid rules are state-specific. That is the 13th principle. Medicaid planning is local. A strategy that works in Florida may not work the same way in California, Ohio, Pennsylvania, or New York. A deed available in one state may not exist in another. A state may define estate recovery differently. Penalty divisors differ. Exemptions differ. Administrative practices differ. This is why a general estate attorney may not be enough. You need someone who practices elder law and Medicaid planning regularly. The source recommends looking for a certified elder law attorney, or CELA. That certification can be useful because it indicates specialized experience. Whether or not a lawyer has that specific certification, the deeper principle is that the lawyer must understand Medicaid planning, not just wills. A standard will is not a Medicaid plan. A power of attorney is not a Medicaid plan. A revocable living trust is usually not a Medicaid Asset Protection Trust. A deed without proper planning may not protect what you think it protects. Families often walk into an estate attorney's office and ask for a will. The attorney gives them a will. Everyone feels responsible. But the long-term care conversation never happens. Then, years later, the nursing home bill appears, and the family realizes the will did not protect the house from Medicaid estate recovery. That is the 14th principle. A will controls where assets go after death if assets remain. It does not automatically protect assets from long-term care costs. This is one of the biggest misunderstandings in estate planning. A will says who receives your property, but if the property must be sold to repay a Medicaid claim, the will may not accomplish what the family expected. The heirs only receive what is left. If the state or nursing home claims most of the estate first, the will distributes the remainder, not the dream. That is why long-term care planning must be integrated into estate planning. Estate planning without long-term care planning can be incomplete. Now let us talk about why attorneys may not bring this up. The source suggests that a standard will may cost a few $100s, while a Medicaid Asset Protection Trust can cost $4,000 to $12,000 to set up correctly. That difference matters. Some clients come in asking for the cheapest document. Some attorneys do not want to complicate the conversation. Some general estate attorneys may not specialize in elder law. Some may not want to discuss Medicaid planning unless the client raises it. Whatever the reason, the burden often falls on the family to ask the right question. That is why knowing the phrase matters. Medicaid Asset Protection Trust. Say it out loud. Ask whether you qualify. Ask whether it fits your state. Ask what assets should be included. Ask what control you lose. Ask what income rights remain. Ask how the home is treated. Ask how the trust is funded. Ask how the 5-year look-back applies. Ask what happens if care is needed before 5 years pass. Ask whether a Lady Bird deed is available if you live in one of the states where it may be used. Ask about tax consequences. Ask about capital gains basis. Ask about property tax reassessment. Ask about trustee selection. Ask about beneficiary rights. Ask about how the trust affects family dynamics. This is not a small decision, but not asking can be far more expensive. That is the 15th principle. The question you fail to ask can cost more than the document you thought was expensive. Now let us build the practical checklist from the source. First, pull the last 60 months of bank statements and identify transfers to family members, especially transfers over $500 as the source suggests. The purpose is not to panic. The purpose is to understand exposure. If you do not know what transfers occurred, you cannot have an intelligent conversation with an elder law attorney. Second, look beyond bank statements. Think about property transfers, car transfers, loan forgiveness, tuition payments, wedding help, large gifts, charitable donations, and anything sold below fair market value. Medicaid planning is not only about checks. Third, find a specialized elder law attorney, ideally someone whose practice includes Medicaid planning regularly. A general estate attorney may be helpful for wills and powers of attorney, but may not be enough for complex long-term care planning. Fourth, ask directly about a Medicaid Asset Protection Trust. Do not assume the attorney will bring it up. Ask by name. Fifth, if your state allows a ladybird deed and it is appropriate, ask whether it can protect the home or help avoid probate and estate recovery. Sixth, fund the trust properly if you decide to use it. Retitle the assets, follow through, keep records. Seventh, educate adult children. The rule affects them because estate recovery affects inheritance. And in some states, unpaid care bills may create exposure for adult children. That is the 16th principle. Medicaid planning is a family conversation, not only a senior's paperwork. Adult children often do not know about gifts, transfers, deeds, bank accounts, or long-term care risks until crisis. By then, the healthy parent may be overwhelmed, the ill parent may be incapacitated, and siblings may disagree. Planning early prevents chaos later. The family should know where documents are, who holds power of attorney, what accounts exist, what assets are in trust, what gifts were made, what long-term care insurance exists, if any, what the home title says, what state rules apply, who the attorney is. This information can prevent panic. Now let us think about the emotional resistance to planning. Many seniors do not want to talk about nursing homes. They worked all their lives, they own a home, they hope to stay there. They do not want to imagine losing independence. Children may avoid the conversation because it feels disrespectful. Families postpone the issue because it is unpleasant. But avoiding a risk does not reduce the risk, it often increases it. That is the 17th principle. The conversation you avoid is often the conversation that later controls you. Planning for long-term care does not mean you expect to need it. It means you understand the possibility. The same way you buy insurance without hoping for a fire, the same way you write a will without hoping for death, the same way you create an emergency fund without hoping for an emergency. Good planning is not pessimism. It is respect for reality. Now, let us discuss the moral problem. Many seniors gave gifts from love. They helped children because family needed help. They gave holiday checks because that is what they always did. They helped with tuition because they wanted grandchildren to have better lives. They paid for a wedding because family mattered. Then the Medicaid system can treat those gifts as transfers that create penalties. This feels cruel because the family intent was generous, but large systems are often indifferent to intent. They operate through rules. The caseworker may not know the story. The formula may not care about the birthday. The divisor does not know the granddaughter's name. The penalty period does not care that the senior never meant to avoid care costs. That is the 18th principle. A bureaucracy processes facts, not feelings. This is why you must plan before feelings enter the crisis. Once the file is in the system applies the rules. Now, let us think about why a Medicaid Asset Protection Trust must be done early. The 5-year period is the central problem. If the trust is created and funded more than 5 years before a Medicaid application, assets inside it may be protected. If care is needed before the 5 years pass, transfers to the trust may still be within the lookback period and can create penalties. That means the trust is not a last-minute solution. It is an early planning tool. The best time is when the senior is still healthy enough that long-term care is only a possibility, not an immediate need. But that is precisely when most people do nothing, because the risk feels far away. That is the 19th principle. The best planning must be done when it feels unnecessary. If it feels urgent, you may already be late. This is true in many areas of life. You buy insurance before the accident. You save cash before the job loss. You create estate documents before incapacity. You plan Medicaid protection before the nursing home crisis. The cost of waiting is often invisible until it becomes irreversible. Now, the source says the most expensive day in your life is the day after you should have started. That is a powerful line because it captures time risk. Every day you wait is a day that does not count toward the 5-year clock. If you fund a trust today, the clock starts today. If you wait 2 years, the clock starts 2 years later. If a health event occurs during those 2 years, the opportunity may be lost. That is why time is an asset in Medicaid planning, not just money. The 20th principle is this. In 5-year look-back planning, time itself is protection. When you waste time, you lose protection. Now let us consider what happens when no planning is done. A senior enters care, private pay begins, savings are spent down, the family applies for Medicaid. The state reviews 60 months. Transfers create a penalty. The nursing home bill continues. The family cannot pay. A lien or claim may be filed. The senior dies. Estate recovery begins. The house is sold. Heirs are shocked. Siblings argue. Adult children feel guilty. Everyone says, "If only we had known earlier." That phrase appears too often, "if only we had known earlier." The purpose of this kind of information is to eliminate that sentence. That is the 21st principle. Planning is successful when it prevents future regret. Now let us talk about the difference between protecting assets and hiding assets. A legitimate Medicaid Asset Protection Trust is not about hiding assets. It is legal planning using established rules, done in advance, with proper documents, proper funding, and proper disclosure. Hiding assets, lying on applications, or failing to disclose transfers can create serious legal problems. Do not confuse planning with fraud. That is the 22nd principle. Legal planning works because it follows the rules before the crisis. Fraud tries to evade the rules after the crisis. Families should never lie on Medicaid applications. They should not hide transfers. They should not play games with records. The correct path is to plan early with qualified professionals. This is not a do-it-yourself game. The stakes are too high. Now, there is a major trade-off in Medicaid Asset Protection Trust planning. Once assets are transferred to an irrevocable trust, you give up direct control that can create family issues. Who is trustee? Are the children responsible? What if family relationships change? What if a child has creditors, divorce, addiction, or poor judgment? What if you need access to principal? What if laws change? What if you regret the decision? These questions matter. A map can be powerful, but it is not automatically right for everyone. That is the 23rd principle. A protective structure must fit the family, not only the statute. If the wrong child is trustee, the plan can create conflict. If the senior cannot tolerate giving up control, the plan may not work emotionally. If assets are needed for lifestyle, locking them away may be too restrictive. If tax consequences are misunderstood, the plan may create surprises. This is why specialized counsel matters. A good elder law attorney should explain not only the benefits but also the costs, trade-offs, and alternatives. Now, what are alternatives? Long-term care insurance may be one, though it can be expensive and may not be available or affordable for everyone. Hybrid life insurance and long-term care products may be another. Spending down strategically may be necessary in some cases. Half-a-loaf planning may help in crisis. Lady Bird deeds may help in certain states for the home. Caregiver agreements, if done properly and in advance under state rules, may sometimes be relevant. Annuities may be used in some Medicaid planning contexts, especially for married couples, depending on state law. But these are specialized strategies. The source document focuses on the map because it is the primary document families need to ask about early. That is the important point. Do not rely on generic estate documents alone. Ask specifically about long-term care exposure. Now, let us talk about probate. Assets passing through probate can be exposed to estate recovery claims. A trust or deed structure that avoids probate may reduce exposure depending on the state's estate recovery definition. But states differ. Some states have expanded estate recovery definitions that can reach beyond probate assets. Others are more limited. This is why state-specific advice matters. Again, the principle is local law. A strategy described in one state may not work in another. This is the 24th principle. Probate avoidance and Medicaid protection overlap, but they are not identical. A revocable living trust may avoid probate, but because you still control the assets, it usually does not protect those assets from Medicaid eligibility rules. An irrevocable Medicaid Asset Protection Trust is different because control is limited and the assets are moved out of direct ownership. Families often confuse revocable trusts and irrevocable asset protection trusts. This confusion can be expensive. A revocable trust can be useful for probate planning. It is not usually enough for Medicaid asset protection. Know the difference. Now let us think about the house as an emotional asset. A house is not only money, it is memory, it is where children grew up, it is where holidays happened, it is where spouses aged together. It is the place someone hoped would become a legacy. That is why estate recovery is so emotionally devastating. The family is not only losing equity, it is losing a symbol. But the state sees an asset, the nursing home sees a bill, the legal system sees an estate. That gap between family meaning and institutional treatment is painful. That is the 25th principle. The system sees property where families see legacy. Planning is how you protect legacy from being reduced to a repayment source. Now let us talk about why this applies even to people with modest assets. Some families think Medicaid planning is only for the rich. That is wrong. The very rich can often self-fund care or buy extensive insurance. The poor may already have few assets to protect. The people most exposed are often middle-class seniors who own a home, have some savings, and assume that a will is enough. They are not rich enough to ignore the system. They are not poor enough to be unaffected by the asset rules. They are in the middle. And the middle is where the home often represents most of the family wealth. That is the 26th principle. Medicaid planning is often most important for the people who think they are too ordinary to need it. A senior with a paid-off home and modest savings may think they do not have enough to justify a complex plan. But the home may be worth hundreds of thousands of dollars. A Medicaid claim can consume a large part of that value. A few $1,000s spent on proper planning early may protect far more later. Again, not in every case, but often enough that the conversation is essential. Now let us address another misconception. Some people think they can simply put the child's name on the deed and solve the problem. That can be dangerous. Adding a child to the deed may be treated as a transfer. It may start a lookback issue, it may create tax consequences, it may expose the home to the child's creditors, divorce, lawsuits, or financial problems. It may cause capital gains issues, it may create family disputes. It may not protect against estate recovery the way people assume. Do not do deed changes casually. That is the 27th principle. Simple-looking deed changes can create complex legal and tax problems. Always get advice before moving title. The same applies to bank accounts. Adding a child as joint owner can create issues. The money may be exposed to the child's creditors. It may be treated differently for Medicaid or estate purposes. It may create conflict among siblings. Convenience can create risk. Use proper documents. Now, let us think about power of attorney. A durable power of attorney is important because someone may need authority to act if the senior becomes incapacitated. But the power of attorney must include the right powers. Some standard forms may not allow gifting, trust funding, or Medicaid planning actions. If the document is too narrow, the agent may be unable to complete planning when it is needed. This is why elder law attorneys matter. The power of attorney should be designed with long-term care planning in mind if that is the goal. That is the 28th principle. Authority to act later must be created while the senior still has capacity. Once capacity is lost, options shrink. This is why waiting is dangerous. A senior may be healthy today and able to sign documents after a stroke or dementia diagnosis. That may no longer be true. Then the family may need court involvement, guardianship, or conservatorship. That costs time, money, and stress. Plan while capacity exists. Now, let us talk about records. If you made transfers in the last 5 years, documentation matters. Was it repayment of a loan? Was it payment for services? Was it a gift? Was there a caregiver agreement? Was there fair market value? Was there a written note? Was the car sold below value? Was tuition paid directly? Was the transaction properly explained? The state will look at the records. If records are missing, the family may have a harder time proving the nature of the transfer. This is why the source says to pull statements and make a list. The list gives the attorney a starting point. Do not hide the list. Do not guess. Do not wait for the caseworker to discover it first. That is the 29th principle in Medicaid planning. Clean records are protection. Now, let us discuss the emotional cost to adult children. Children often receive gifts with no idea that those gifts could later create a penalty. They may spend the money, then the parent needs care, the penalty is calculated, the nursing home bill appears, the child may feel guilty, blamed, or financially pressured. This can damage family relationships. A gift that was meant to express love becomes a source of conflict. Planning reduces that risk. If parents understand the rules, they can give in ways that fit the plan. If children understand the rules, they may be more cautious about accepting transfers late in a parent's life without discussing consequences. That is the 30th principle. Medicaid ignorance can turn generosity into family conflict. Now, what about charitable giving? The source notes that charitable donations over certain thresholds can count depending on the state. This surprises people because they assume charity is always treated favorably. But again, the Medicaid system is focused on asset transfers. If assets were transferred away during the look-back period, the state may examine them. This does not mean seniors must stop all giving. It means they should understand state rules and document recurring patterns if necessary. If someone always gave modest amounts, that may be viewed differently than a sudden large gift depending on rules and facts. But do not assume, ask. That is the 31st principle. Assumptions about generosity do not override eligibility rules. Now, let us consider why the nursing home does not wait. A nursing home is a business. It has staff, rent, or debt, insurance, food costs, medical costs, regulatory costs, and administrative costs. If Medicaid does not pay and the patient cannot pay, the facility has a receivable. It may pursue the family or estate depending on law and contract. It may place liens or pursue legal claims. The facility is not the family's financial planner. Its job is to collect payment for care. That is why families must plan before entering the facility. Once the facility is involved, the leverage changes. That is the 32nd principle. The care system is designed to provide care and collect payment, not to protect your inheritance. Inheritance protection is your planning responsibility. Now let us talk about timing again. Month 61 is different from month 59. A transfer made 61 months before application may be outside the lookback. A transfer made 59 months before application may be inside. That 2-month difference can be worth tens or hundreds of thousands of dollars. This is why the clock matters so much. It seems arbitrary. It may feel unfair. But the rule is the rule. A family that plans early may keep the house. A family that waits may lose it. That is the 33rd principle. In legal planning, dates are not details. Dates are outcomes. The trust funding date, the transfer date, the application date, the nursing home admission date, the penalty start date, the death date, the probate date, each can matter. Planning is partly controlling dates before dates control you. Now let us think about what a Ray Dalio-style system would say. Every outcome has causes. If a senior gives assets away within 5 years and then applies for Medicaid, the state sees a transfer. If the state sees a transfer, it calculates a penalty. If there is a penalty, Medicaid does not pay for a period. If Medicaid does not pay, the nursing home bill continues. If the bill is unpaid, the home or family may become the target. If the recipient dies after Medicaid paid, a state recovery may activate. If the house is in the estate, the state may claim against it. If there was no trust, deed strategy, or planning, the heirs may lose the house. That is the causal chain. The solution is to interrupt the chain early. Fund a Medicaid Asset Protection Trust more than 5 years before care is needed, if appropriate. Use a Lady Bird deed where available and suitable. Keep records. Avoid careless gifting. Use elder law counsel. Educate the family. This is systems thinking. Do not wait until the chain is already moving. Now let us be honest about the cost of planning. $4,000 to $12,000 for a properly drafted trust can sound expensive. It is expensive for many families. But compare that with 1 year of nursing home care at more than $108,000, or with a home worth hundreds of thousands of dollars exposed to a state recovery. The question is not whether planning costs money. The question is what not planning could cost. That is the 34th principle. The price of protection must be compared with the cost of exposure. A $200 will may be appropriate for a simple estate with no long-term care concern, but if the family's main asset is a home vulnerable to Medicaid recovery, the cheapest document may not be the right document. Cheap can become expensive. Now let us discuss long-term care insurance briefly. Some people avoid Medicaid planning by buying long-term care insurance or hybrid products that can work for some, but premiums, underwriting, benefit limits, inflation riders, and policy terms matter. Some people are too old, too unhealthy, or unable to afford coverage. Others may find it useful. The source focuses on Medicaid planning because many families will not have enough insurance. The principle is broader. Plan how care will be paid for. Do not assume the answer will appear later. That is the 35th principle. Long-term care is not a medical issue only. It is a financial event. A nursing home can become one of the largest expenses in a family's history. Treat it that way. Now, let us think about what seniors should not do after learning this. Do not immediately give away assets without advice. Do not put children on deeds casually. Do not empty bank accounts. Do not hide money. Do not file a Medicaid application without understanding transfer exposure. Do not assume your will protects the home. Do not assume the IRS gift exclusion makes gifts safe. Do not wait until diagnosis. Do not rely on a general internet checklist as legal advice. Do not let adult children pressure you into transfers that may later hurt everyone. That is the 36th principle. Panic planning can be worse than no planning. The right response is calm, qualified planning. Now, what should be done? Gather records. list transfers, review asset ownership, review home title, review powers of attorney, review wills and trusts, estimate long-term care exposure. Find a certified elder law attorney or Medicaid planning specialist. Ask about a Medicaid Asset Protection Trust by name. Ask about state-specific deed options. Ask about the Community Spouse Resource Allowance. Ask about half a loaf only if care is already needed or near. Ask about estate recovery. Ask about filial responsibility if your state has those laws. Ask about tax consequences. Fund the plan properly, educate the family, then review periodically. That is the action system. Now let us think about how this affects adult children. If your parents are aging and own a home, this is not only their issue. It may affect whether the family home survives. It may affect whether children are sued for unpaid care bills in certain states. It may affect whether gifts received years earlier create problems. It may affect whether siblings blame one another later. But adult children must approach the conversation respectfully. Parents may feel threatened if children suddenly ask about assets. The correct framing is not, "I want my inheritance." The correct framing is, "I want to make sure your care and your home are protected if something happens." This is a planning conversation, not a grab for property. That is the 37th principle. Family planning works only when trust is preserved. Do not make seniors feel like assets are being taken from them. A Medicaid Asset Protection Trust already requires giving up some control. The emotional side matters. The senior must understand why, how, and what rights remain. Good planning respects dignity. Now let us discuss the healthy spouse again. Many couples assume all assets are shared and will remain available. Medicaid divides the world into countable and exempt assets, institutional spouse and community spouse, allowed resources and spend-down requirements. This language can feel cold and confusing, but the financial outcome can be severe. If one spouse needs care, the other spouse's future must be protected. A good Medicaid planner looks not only at preserving inheritance, but also at making sure the healthy spouse is not left financially broken. That is the 38th principle. The first goal is protecting the living spouse. Inheritance comes after survival. Families sometimes become focused on preserving the house for heirs. That matters. But the healthy spouse needs cash, shelter, and stability. First, a plan that protects heirs while leaving the spouse vulnerable is not a good plan. This is why professional advice matters. Now, let us think about the ethical question. Some people may say Medicaid planning is wrong because taxpayers pay for care while families preserve assets. Others may say it is fair because families are using legal rules, paid taxes for years, and are trying to avoid total impoverishment. This debate exists. But from the family's perspective, the law allows planning if done correctly and in advance. The system itself sets the 5-year rule. It says transfers outside the period can be treated differently from transfers inside the period. Families have the right to know the rules and plan within them. That is not hiding. That is legal planning. That is the 39th principle. Using the law before a crisis is different from abusing the law. During a crisis, families should act legally, transparently, and with advice. Now, let us discuss Medicaid versus Medicare. Many seniors confuse them. Medicare is the federal health insurance program for older adults and certain others. It does not generally pay for long-term custodial nursing, home care in the way families imagine. Medicaid is the program that may pay for long-term care if eligibility rules are met. The distinction matters because people who think Medicare will cover the nursing home bill may delay planning. The source focuses on Medicaid because that is where the 5-year look-back appears. That is the 40th principle. Knowing which program pays for what can determine whether you plan in time. Do not assume Medicare solves long-term care. It usually does not solve the extended custodial care problem. Now, let us return to the emotional core of the story. A parent worked for 40 years, paid taxes, paid the mortgage, maintained the home, gave gifts to children, tried to help grandchildren. Then, near the end of life, a health crisis forces a move into care. The cost is unbearable. Medicaid is needed. The state reviews 5 years. The gifts become penalties. The spouse is limited. The house is exposed after death. The children are shocked. This is not rare enough to ignore. It is not something that happens only to irresponsible people. It can happen to families who did almost everything right except ask the right question early enough. That is the 41st principle. In elder care, good intentions do not replace planning. Now let us think about what makes the 5-year rule psychologically unfair. People do not live life expecting that a gift today may be evaluated by a government caseworker years later. They do not write a Christmas check thinking about a regional penalty divisor. They do not help a grandchild thinking about a nursing home application in month 47. They do not sign over a car thinking about Medicaid eligibility. The system sees a transfer. The family saw love. That mismatch is why education matters. If families understand the rule, they can be generous in ways that do not destroy eligibility. They can plan before giving. They can protect assets before care is needed. They can make deliberate choices without knowledge. Love can become exposure. Now let us discuss the role of urgency. This is urgent, but not because everyone needs to rush into a trust tomorrow. It is urgent because the 5-year clock is long. Planning must happen before the need is visible. If you are already 65 or older, the possibility of long-term care is not theoretical. It may never happen. But if it does, the cost can be life-changing. You do not need certainty to plan. You need probability and consequence. The probability of needing some form of long-term care is not trivial. The consequence of needing care without planning can be enormous. That combination justifies action. That is the 42nd principle, high consequence. Risks deserve planning even when timing is uncertain. Now, let us talk about reviewing the plan. A Medicaid Asset Protection Trust is not something you create and forget forever. Laws can change, family circumstances can change, trustees can change, assets can change. A home may be sold, investments may be added, a spouse may die, a child may divorce, a beneficiary may have creditor issues. A state may modify rules, review periodically, make sure the trust remains funded and aligned with the family's goals. Make sure records are clear, make sure powers of attorney are updated, make sure the plan still fits. That is the 43rd principle. A plan is a living system, not a one-time document. Now, let us think about what can still go wrong even with planning care. May be needed before 5 years pass. The trust may be funded incorrectly. Assets may be left outside the trust. The wrong trustee may be chosen. State law may change. Tax consequences may be misunderstood. Family members may disagree. The senior may need funds trapped in the trust. A house may be sold and proceeds mishandled. A lawyer may not be specialized enough. These risks do not mean planning is useless. They mean planning must be done carefully. That is the 44th principle. The quality of implementation determines the quality of protection. Now, let us bring this toward the conclusion. The 5-year look back is not really about 5 years. It is about whether you understand that long-term care can turn a lifetime of assets into a spend-down target. It is about whether ordinary gifts can be treated as disqualifying transfers. It is about whether a spouse can be left with far less than the family expected. It is about whether a house that seems safe during life can be claimed after death. It is about whether adult children can become exposed to unpaid care bills in certain states. It is about whether the right document was created and funded early enough. The Medicaid Asset Protection Trust is not magic, but for families who qualify and plan early, it can be a powerful shield. A ladybird deed may help with the home in certain states. Loaf planning may reduce damage when planning is late, but the cleanest strategy is early action, 5 years early, funded properly. With specialized counsel, that is the message. Now, I will state the principles one more time. First, the rule is most dangerous because people learn it too late. Second, the look-back reviews 60 months of transfers before Medicaid pays. Third, gifts allowed by the IRS can still create Medicaid penalties. Fourth, the penalty is a period where Medicaid refuses to pay while the nursing home still bills. Fifth, the house may be exempt during life but exposed to estate recovery after death. Sixth, the healthy spouse's resource protection may be far less than a lifetime truly requires. Seventh, adult children can face unexpected exposure in some states. Eighth, late-stage strategies exist, but they are damage control. Ninth, the Medicaid Asset Protection Trust must be created and funded before the 5-year clock can protect assets. 10th, the right lawyer matters because a simple will is not a Medicaid plan. 11th, state law matters. 12th, records matter. 13th, planning protects family relationships as well as money. 14th, the most expensive day may be the day after you should have started. This is how I would think about it. Not emotionally, systematically. If you own a home, have savings, and want your family protected, do not assume the system will explain itself in time. It often will not. The system will simply apply the rules. Your job is to understand the rules before they apply to you. Ask the phrase by name. Medicaid Asset Protection Trust. Ask whether your state has a ladybird deed. Ask what transfers in the last 5 years mean. Ask how estate recovery works. Ask how your spouse is protected. Ask what happens if care is needed before 5 years pass. Ask what must be done to fund the trust. And ask now. Because once the nursing home bill begins, once the application is filed, once the transfer is inside the lookback, once the house is in the estate, the options shrink. The 5-year rule does not forgive ignorance. It rewards preparation. That is the hard truth. And if your home represents a lifetime of work, if it represents your spouse, security, your children, inheritance, or your family, stability, then this is not a small administrative issue. It is one of the most important financial conversations your family may ever have.